Hello, everyone, and welcome to today's Business Law Bootcamp presentation, Choice of Corporate Entity. I would now like to introduce Phil Bogart and Jordan Halle. Phil, welcome.
Thanks, all. Actually, this is Trent Sifkovich. I'm going to step in and introduce everyone on behalf and the context on behalf of the corporate section. So as part of our Business Law Bootcamp program, we try to identify core issues that can not only help you as attorneys in your practice in gaining your base knowledge of of legal issues, but also how do you potentially spot issues that you might come across in your individual practice, be they litigation or employment or bankruptcy or whatever. How often are there issues that might pop up where you might hear something, catch something that triggers a question? So being armed with the basic knowledge of choice of entity is a wonderful thing. Frankly, it's also a good thing because how many times when you have a conversation at a picnic in the summertime, or you're sitting around the dinner table at Thanksgiving or afterwards, that crazy uncle or the strange neighbor saddles up to you and goes, "Hey, I've got this great idea for business," and then you launch into this discussion. And so, frankly, this really is one of those things on the business law side that we very, very often do run across. And there's a section as we're thinking about how to present this. A few names popped up that were a perfect fit for this. Phil, in his practice, representing a lot of smaller business owners, particularly in the medical and dental fields, deals with this quite a bit and has significant experience. Jordan, in his experience, focusing on primarily tax issues within the corporate realm, can definitely focus in on what are the implications of choices that might be made for business parties, not only the operation of the business, but what happens if there comes a time when they sell the business? What are the issues you have to think about there? And so, with that, I want to turn it over to those two and let them run with it and take it from here.
Okay, well, thank you, friends. It's a little daunting to give this presentation. I have to look around the room and on the screens, people have been practicing longer than I have, and so please interrupt me to correct me or to comment, not just questions, but hopefully this is more of a dialogue than a presentation. Before we get started, just a couple of introductory remarks. First of all, I think we all can attest to this from our own practice. Clients don't always like to give us all the information. Sometimes you have to kind of pull it out like pulling teeth. And so whenever you have a conversation with a client about what type of entity to form, usually they don't tell you everything until you talk about it. So everything that we discussed today is going to be very, very sensitive to what the facts are, and what a client may think they want isn't always true. So, for example, a lot of times I get a call saying, "Please form a Delaware C Corp for me," which might be the right choice. It may not be the right choice, but sometimes people read things out there, or they have certain understandings that maybe aren't really true. And so, probe and ask a lot of questions. When it comes to forming an entity, it's always very tax sensitive. The right choice can make a big difference, and the wrong choice can be very painful, as Jordan will talk about later on. In fact, I think more of this presentation is going to be with Jordan talking about the different tax differences, because that's really where the differences lie. Many of the differences lie. And lastly, I think most importantly, which is what Trent mentioned about the crazy uncle that wants to be your client. First of all, as a firm, we probably don't want to represent your crazy uncle. At least I know I don't. Those engagements never end well. But I think back to my early days practicing, and the first couple of years when you practice, you don't really know too much. But forming an entity is easy, and I have a client to this day that I put it out there to some CPAs. I'll form an entity at cost. Marty, I guess I should ask whether I'm allowed to do this, but I just looked online, and many sophisticated people go to LegalZoom to form their LLC. And you could form an LLC on LegalZoom for like $79 plus filing fees. And like I always say, why can't we do that? We'll pass on the filing fees. We won't do it at a loss, but it can be a wonderful way to get your foot in the door. I have a client to this day, over the last 10 years, he's probably paid close to $200,000 in fees, close to this firm and my prior firm. And it all started because he needed to set up an LLC for his wife. And once he had my number, once he had, the relationship with me, he would call me from time to time. So it can really be a great opportunity to get clients. Sometimes litigators have trouble bringing on business clients, and it really doesn't have to be that hard. Next month, we're gonna talk about agreements, like partnership agreements and LLC agreements, and it's another way to get people in the door. I mean, how many people do we know that have partnerships that don't have agreements? And we're going to talk about how important that is. And I've done this many times. I'll say, you know what, let's go out to lunch. Let's talk about why you need an agreement. And then you have a new client. It's that easy. So these training sessions can be great for cross-selling, for business development.
And just kind of jumping off of this and the idea that this isn't a DIY and just how easy it is, Maryland has made a huge push to really digitize a lot of what they do, especially the business side. So right now, you can actually form an LLC, even without LegalZoom. You can go on to Maryland's website, type in your name, your address, your resident agent address, which is usually going to be the person's same address, and boom, file an LLC, form an LLC with no real formalities having been done, no consultation with an attorney, just 5 minutes, and you're now an established company in the state of Maryland. And people just don't really necessarily think about what actually goes into forming their company, what the next steps are. And what additional, requirements, what the additional language you might want in an LLC, articles of organization, which is what we're. So that point that Phil makes that this is not a DIY project is harder to get across because of how easy it is.
Just a quick question.
Sure.
We just got started.
Yeah.
In the situation where someone has already done just filled out the form.
Mm-hmm.
Is it more difficult for you all to come and clean it up after the fact if there's a conversion that needs to be made or what have you? Because I guess I think that's always part of the pitch.
I think that's a great point. It's a great point. In the last couple of years, there's a new statute in Maryland that you can easily convert corporations to LLCs, and putting aside the tax issues, which there are, it's another conversation to have. Someone says to you, I have a C Corp or a corporation or something, and sometimes there's an easy fix that we can help out with. So lastly, many accountants are happy to form entities for their clients, and you've probably had situations where they mess things up because they practice law when they shouldn't practice law. And so I've told several CPAs the same thing. I'll make you look good. I'll form the LLC for you. Just give me your fees. Let me open up a file for the client, and I'll do it. So it's a great way to sell your services to CPAs. CPAs can be excellent referral sources. Okay, so that's the introduction. We're going to talk about the following entities. The first one's really not an entity: sole proprietorships, different types of partnerships, LLCs, corporations, closed corporations, professional corporations, and we'll get to each one. We're going to try to compare and contrast these. Along with your slides, you also should have a printout from PLI, a nice checklist, which really, it compares each of the different entities without getting into the various state issues, but it's a nice little cheat sheet to know what to do, and it could be a nice conversation piece for people. So you can look at this along with our conversation. Okay, so first of all, why form an entity? I think everybody knows this is probably one of the early things you learn if you take a business associations course in law school. It's to insulate the owner from liability, and as long as they observe the formalities, meaning they don't pretend like the entity is their own. Rarely do courts pierce that corporate veil, and it can be a way to shield the owners from personal assets. And we're going to see with partnerships, there's a certain nuance that I want to point out. you can you can own a business without being an LLC. You can register a trade name without having an entity. Right now, I have a new client. It came from a deal that went bad, but we represent a landlord that's suing its prior tenant in Colombia. The prior tenant is actually a lawyer, successful. He thinks he's a successful lawyer. He's a lawyer. Let's put it that way. And we are suing his entity for back rent, and it turns out that his LLC never existed. And so although there was no personal guarantee on the lease, he thought he had an LLC. He didn't have an LLC, and so we're going after him individually. So it's nice to have an LLC or a corporation or whatever entity that you choose.
Just out of curiosity, for a couple new associates, don't mean to call you out, just I'm curious, have you taken a business law course while you were in law school? Okay.
BA, yep.
I wanted to make sure I knew kind of, who we were talking to.
Mm-hmm.
Okay, so sole proprietorships. This is an entity, although it doesn't give you that shield. It's owned by one individual. There's nothing to it, no formalities. Schedule C, the 1040, and again, there's no shield. I've had many situations where somebody buys investment property and owns it with his wife or with a brother or with the family, and no entity whatsoever, and there's really no reason for it. In my practice, when I work with lots of doctors and lawyers, I have many practitioners that don't form entities because they think that their malpractice insurance will be sufficient. And in fact, with doctors and dentists and lawyers and certain other professionals, even if you have an entity, you could be sued personally for malpractice. And so many professionals feel like they don't need an entity because they have malpractice insurance, and it's not necessarily true, because if there's a slip and fall case, if there's something that's not malpractice, there can be liability, and if it's owned by more than one person, one partner could be liable for the other partner's acts, and we'll get into that right now when we talk about general partnerships. So a general partnership is, again, it's more than one. It's easy. More than one person owns and runs a business venture. Now with that, it's governed by the Maryland Revised Uniform Partnership Act of the Maryland Code. If you're interested in reading, it's every time I read it, I learn something new. So it's good to know. It's good to read through. Some things you assume are true are not necessarily true. But each partner has unlimited liability, and so you'll find many times with these, they do buy insurance, but it doesn't always help everything. You don't need any state filing to form the entity, although there are some state filings you make for the personal property returns. If there's an agreement, the agreement governs the rights, the partners vis-a-vis each other, and transfers and ownership and management. Usually it would be in the agreement. If it's not in the agreement, it's covered by the act. There's a Maryland Revised Uniform Partnership Act. Many states have very similar acts because it's based upon the same Uniform Partnership Act that was adopted statewide or nationwide by many states. If you are going to have a general partnership, you should have an agreement because you need to customize your deal. If you have no agreement, again, it's governed by the code. People that do want to have general partnerships because they feel like there's a reason for it. Certain times there are tax reasons why you want to have it, but there are ways to nevertheless insulate your personal liability because you can have two LLCs or two corporations being the partners. And so that is one way to kind of shield the individuals from liability. But having said that, general partnerships are usually not a good idea, but there are exceptions. Okay. Again, almost never makes sense to have one. Okay, so going on to limited partnerships. So this is where you have one general partner, one limited partner. The general partner has unlimited liability, generally runs the show, and the limited partners are what you would call silent partners, and they have very limited rights. The rights of each party is would be in the agreement that you have. So you can have the agreement. I mean, the law allows you to customize your agreement. If the agreement doesn't deal with a certain situation, then there are default rules in the Act that deal with those. Again, unlimited liability for the general partners. The limited partners' liability is limited to their investments. Okay. So again, here as well, many times the general partner will have an entity to shield its own personal assets. So when I started practicing law in 1999, although it was a few years after the LLC Act was enacted and adopted in many states, there were still many lingering LPs. I think there still are a bunch of lingering LPs.
Real estate partnerships.
Real estate has, yeah, so you'll still find these in various real estate deals. I mean, I get the sense new deals have LLCs or not necessarily, okay? So you still will see a lot of LPs, probably because they're formed back in the 80s. Okay, but here, which is different than the general partnership, there's a specific state filing that you need to make to form you. So whether you're in Maryland or Pennsylvania or DC, to form the LP, you need to have a state filing. And if you don't, then you're deemed to be a general partnership. Okay, so I don't know the year exactly, but as the LLC got popular and people talked about the concept, people liked the idea of the general partner having limited liability, and so additional amendments were made to the general partnership law and the limited partnership law, where a general partnership can make a filing with the state to become, instead of a GP, an LLP, which then provides that general partnership, the general partner, with its insulation from liabilities. And limited partnerships can also provide an insulation from liability for the general partners. And so you can have an LLLP or an LLP, depending upon whether you're a general partner or a limited partnership, which then does away with the liability of the general partners. It is very specific to state law. So whereas in Maryland, I believe there is insulation from liability for the general partners, with a few exceptions, some states have a few more exceptions. And so certainly look at your state law to make sure you're telling the client the right thing. But the point is that if you have a GP or you have an LP and they need to have those entities around, then there's no reason not to file for an LLP or an LLLP to get that insulation from liability. Okay.
On that one, why would you ever have an LLP if an LLLP is available to you? Why would the general partner ever expose himself if he has the option to limit through this, arrangement?
So the code actually refers to both as LLPs, but an LLP is a general partnership that elects to be an LLP. A limited partnership is one that makes that election to be an LLLP, but the rules will be the same. Each made the same election, and each provide the general partner with the insulation. Does that answer?
One of the things that happened was originally there were the general partnerships, and then the limited partnerships came in, and then the LLCs came in, and then later on the LLLPs came in. And so you often had a procession of changes in state law across the country as these concepts became adopted, and states at times were also hesitant to allow a party to transfer tax-free and convert from one form to another. And so it was very incremental, and so you had a lot of additive terminology and protections built on over the last 20 years. And so frankly, a lot of it doesn't make sense. A lot of these mid-late, the LLPs and the triple LPs and all that, frankly, LLC is a lawyer's likely choice for a reason. You don't deal with a lot of that stuff often, and they're sort of hangovers.
What's the difference between a joint venture and a partnership?
I mean, the code seems to use the words interchangeably, but it's a good question.
There aren't special tax considerations for a true joint venture, but those are extremely limited. So even for tax purposes, it's the same question of are they two businesses or two individuals exchanged in a business, engaged in business for profit. Most of the time, it's going to be considered a partnership. Yeah, but without there being a separate filing. But that's why even joint ventures, you know, I've worked on plenty, and the joint venture is almost always an LLC. Right, that's your joint venture. So a JV isn't a separate concept in terms of state law and tax law.
And the limitations on liability, are those one directional, meaning what they do is they prevent the liability from flowing down in the family tree, but what about liability flowing up?
You mean the LLP being responsible for the General Partners Act?
Right.
I think if the act, I mean, it depends, but if the act is done in the course of conduct of that entity, I think that the entity has liability. I think so. Yeah.
And then as far as the individuals potentially also being liable, that's where we, in future sessions, when we get into operating agreements and partnership agreements, we'll talk about indemnification. And there can be, and usually are, indemnification obligations imposed so that the state or that the entity indemnifies individuals for any of, you know, certain wrongs that they may have committed, certain negligent acts, for example, usually excluding gross negligence, misconduct, things of that nature.
Good. Another just tidbit when it comes to business development, if you have a client or a potential client that owns property individually or with a family member or a brother or a crazy uncle, there are easy ways to convert to an LLC with minimal costs. It's another way to kind of get new clients. They have a vacation home on the beach and they own it individually and they rent it out. It's an easy to convert it to an entity. Costs are not that high, and then it may lead to additional work.
Yeah, just to add a little bit more color to that concept. There's currently, you know, in Maryland and most states have a direct conversion statute where you file a single piece of paper and your LLP or your limited partnership now becomes an LLC with a simple one-page filing. That's a relatively new development, believe it or not. It used to be that if you wanted to convert an entity that's an LLC into an entity that's a limited partnership or vice versa, you had to form the other entity and then you actually had to merge them and do a statutory merger to get rid of, you know, and have the surviving entity be whatever entity type you wanted. You know, recently I've seen some states that still don't have that type of conversion feature where if you have a corporation, for example, and you want to convert your corporation in state A to a corporation in state B, you actually have to go through a full merger. You have to form a corporation in state B, merge A into B, A goes out of existence, B survives. That's unusual these days, but that wasn't unusual back when we were adding L's in front of our partnership as a shortcut instead of having to do a merger approach.
Okay, moving on to corporations. And so there are C Corps and S Corps, and Jordan will go through the differences between the two, but just by way of introduction, a C Corp is subject to double taxation, where the corporation itself as a party is a taxpayer, it pays taxes, and then when the shareholder gets its money from the corporation, there's another layer of tax, and then there's an S Corp, which is passed through so that there's only one layer of tax. It's passed through to each of the shareholders.
Just to kind of clarify, C and S Corps are tax concepts only for state law purposes in most states. So there are a couple of states that have some different rules, but especially in Maryland, for example, they're just a corporation. And then you elect later on for tax purposes if you want to be a C or S Corp. And I'll explain that later, so get excited.
So it's formed with the articles of incorporation that you file with the state. It's governed by that charter that you file with the state as well as bylaws. And typically, if the corporation is owned by more than one person, there are other agreements that you enter into, shareholder agreement, buy-sell agreements, voting agreements, lots of paper involved with the corporation. The charter deals with basic rules regarding the attributes of the stock and the initial directors. The bylaws deal with how decisions are made, how meetings are held, when meetings are held, but the agreements get into the actual arrangements among the owners. Typically, there's a board of directors, and the board of directors, they are elected by the stockholder or stockholders, and the directors then elect officers to carry out the acts. Usually there's a president, a treasurer, a secretary. There's formalities. You have to have annual meetings to make certain decisions. The president must go to the board to pass certain resolutions. And so there's a lot of, again, paperwork involved. This is one restriction of S-Corps, and we'll say that for you, Jordan.
I've had another question. So sometimes you'll hear a nonprofit referred to as a non-stock corporation. Is it still a corporation for all the other purposes?
Yeah. So in Maryland has a separate non-stock corporation statute, and it says specifically in that statute, if the corporation elects to not have any stock, it's still subject to most of the general corporate law, the exception being that the directors are deemed shareholders for all purposes of the general corporate law. So yeah, it would still be a corporation, it just doesn't have any stock, and it can also elect to not have any members. So then the question becomes, will that non-stock corporation have members, will it not have members? Typically, what we usually see is we'll have like the holding company that's a nonprofit, and that will not have any members. It'll just have its board, and that board will exist in perpetuity. And then it might have supporting organizations under it or other nonprofits underneath it that all have a single member. That single member was that parent nonprofit. So yeah, the Maryland non-stock is the corporation you use when you're forming a nonprofit.
And can we, Delaware, can we assume that this is something of a uniform law so that you'd see it in Virginia and Delaware as well?
This in other jurisdictions also.
I'm just seeing.
Because you're not going to have. Oh, sure, right. Because the idea, remember, the idea for nonprofits is that there's no private inurement, so nobody gets any benefit. So you're not going to have any stock for a nonprofit entity.
They're not supposed to get any.
Not for profit, I should say. Yes.
Okay. And we're going to come back to corporations in a moment as we kind of compare and contrast. But the next common corporation you'll find is something called a closed corporation, which it tries to get rid of some of the formalities that a corporation has. It gets rid of, it has the ability to have no board of directors, so the stockholders make the decisions. And typically, each of the stockholders have veto powers, but the code does reference like an agreement the stockholders enter into to govern the the business and affairs of the corporation. But you'll see closed corporations from time to time. Okay. All right.
So if I can
please
interrupt you again.
I promise you I'm not going to interrupt yours.
Oh, then maybe I should back off.
No.
So we see the interesting thing with closed corporations is they're good, they're useful for protecting minority owners. You know, if you represent a minority investor in a Maryland corporation, you may really want it to be a closed corporation because, as Phil mentioned, you have unanimous required consent, and the big one there is sale of substantially all the assets. We've tripped up, well, we haven't tripped up, but we've had to address that exact situation a couple of times actually, where the clients come to us, they have some interested buyer in their business. They're not a particularly sophisticated, client. They're just a mom and pop. They go into business for forever. Somebody set up their closed corporation thing because we don't have to worry about all these things. But now somebody comes in to buy and they give us their articles and we see this closed corporation election. Well, that means exactly that. Unanimous consent is required for sale of substantially all the assets. So then we have to ask the question, okay, who owns the business? Who are these stockholders? Because we need to make sure we get every single one of them to consent. Where we've had issues is they don't keep good records. They don't have a good record of their stock ownership. So we really need to trace through and make sure we have every single consent, even if, cousin Johnny 5 years ago had an interest and maybe it was recorded, maybe it wasn't, maybe there's some history of it. But from the buyer's perspective, and especially this one case I'm thinking of, the buyer was a sophisticated private equity firm. They wanted to know that, Johnny's not going to come out of the woodwork and say, hey, I didn't consent to this. This whole thing is in default, this void, void ab initio. So it's if you see close corporation, it's not ideal from the perspective of having a business that we can market later on. But again, if you're representing the minority investor, maybe it's useful. But just kind of be aware that it comes with a slate of issues that you may not initially think about. Yep.
3 corporations, CS and close corp. Do you have, without looking it up, any way of knowing, White for Tail and Preston LLP? Okay, I know what kind of business that is.
So remember, the CNS is a tax concept, right? So you're not going to know that unless you look at their tax returns.
Or you can't even get that from
right. There's not going to be a filing that says they're an S corp, but the close corp, and I think, so there is a specific filing with the state that says it must say close corp in your. So
when you go to the SEC website, usually on they have a summary page and it says close, and it says yes or no.
Yep.
So you can quickly find out if they are.
That's right.
Patrick, the S corporation's an election filed with the Internal Revenue Service.
Right, that's what, and I guess if you're dealing with that company, you wouldn't really care what they do with their taxes, but like you said, you might want to know if it's
depending on what you're doing, you might really care what they do with their taxes.
Yeah.
fair enough.
But you'd have to ask. I mean, you'd have to ask, and what we would usually see in M&A transactions is give us your tax returns.
Yeah.
Let us do it. See how you're filing, and then those questions.
I mean, S corporation status permeates a number of, it even flows to what I do.
Mm-hmm. Gotcha.
If they're an S, there's some different things.
But if you have a client or potential client with a corporation and you ask them if they've observed the formalities, many times you'll find that they never issued stock returns, they never had minutes, and there can be disputes as to who the stockholders are. Certainly if they're going to sell their business, the buyer is going to want to know what they've done, and many times I've had acquisitions representing the seller where we had to quickly put together all the paperwork and ratify it, retroactively to get the housekeeping in order. And so from a business development standpoint, again, this might be a nice way to get new clients is you can, if they're looking to sell or get investors and they feel like they need to get their house in order, or even if it's part of their estate plan, they need to make sure they have all their paperwork and we can get the stuff together, we can clean it up, we can have our paralegal do a lot of the work, and it can be a nice way to do some good work and when the client doesn't even know that they need it. Okay.
As a high-level summary, I think sort of a point about the corporations is just the problem with corporations at times is just the amount of paperwork and the formalities that have to be followed. And people being people don't always do it. And it takes time and it takes money to do it. I mean, just little things, little tiny paperwork things can trip you up royally.
And that's a great lead-in to the LLC, because the LLC kind of solves a lot of these issues. But before we get there, I'm kind of a slave to my slides. Just to close the loop with corporations, there are other types of corporations. Marty mentioned non-stock corporations. If you look at the code, you'll see other types of corporations. The one other that I'll mention is just the professional corporations, where many times you'll find that professionals, whether they're licensed professionals, doctors, lawyers, veterinarians, engineers, architects, they will form an entity together. It'll be called a professional corporation or professional association, and they will practice through that entity. And it was one way to get around the doctrine of the corporate practice of that licensed specialty, whatever it is. Although normally you can't practice through an entity, the professional corporation was formed that you could practice through that entity. Of course, now Many states have PLLCs, professional limited liability companies. Maryland does not. I think Pennsylvania does. I think. But professionals are allowed to practice through LLCs as well. Okay. So when is a C Corp appropriate? Almost never. Jordan will go into some of the tax issues, but one thing that I found sometimes is that if you have a foreign investor, sometimes to block a foreign investor or another type of entity to block the ownership, the profits and losses going up to the owners, a blocker corporation might be used to prevent the tax from being passed through to the upper entity. So that's when a C Corp sometimes is needed. Again, you need to give me a reason to have one, but there are exceptions. If you have an entrepreneur, the crazy uncle has an idea to improve something, and they think it's going to be a $1 billion business, and they know they're going to get investors. They know that many times you can only go public with a C Corp. You certainly can't be an S Corp. I think LLCs are starting to, but for the most part, if you're looking to go public or you're looking for venture capital, institutional investors, typically they want you to be a C Corp and they want you to be a Delaware corporation. So many times I get a call from an entrepreneur just at the beginning of their life in that field or that industry or that idea, and they want to be C Corps because they already know that they're going to be the next Amazon. And typically, they can still be an LLC because they can easily convert to a C Corp, and thank you. And so sometimes you will find that these institutional investors want you to be a C Corp, but I think many of them still are willing to invest into an LLC, not an S Corp, but just an LLC, and you can convert. So again, they may press you to be a C Corp, but usually the LLC is just fine. So now, with all the introduction for the LLC, an LLC was adopted early to mid 90s. And what's special about the LLC is the check the box regulation, where you can be an LLC and you can be taxed like you're a sole proprietorship. You can be taxed like a partnership. You can be taxed like an S Corp. You can be taxed like a C Corp. Check the box. And Jordan will go into that more. It's easy to form an LLC. You have one piece of paper with your state. It's governed by the operating agreement. If there is no operating agreement, it's governed by the code, but you don't need to have bylaws in a separate agreement. It's all in that same document. And that document deals with who owns the company, who makes decisions, how is money shared, what happens if somebody dies or is disabled. It should deal with all of those situations. If the agreement doesn't, the code does. The LLC Act has been perfected over the years to deal with all sorts of situations. The LLC is flexible. You don't have to share profits based upon ownership. Jordan, you'll get into that a little bit more. It can be governed. No annual meetings are needed necessarily. It can be governed by a board of directors. It can be governed by a manager, by a president. You can choose your own title. Whatever the agreement says, with a few exceptions, goes. And so you can really customize this to be what you want it to be.
Yeah. To that exact point, the LLC Act even says specifically that this entity is to give the greatest, to the greatest extent possible freedom of contract, unless otherwise specifically stated in the LLC Act. Everything can be separately agreed. So that's why you'll see throughout the LLC Act in Maryland, in most states, especially Delaware, unless otherwise agreed, So that's why, and as we're about to see in the advantages, that it's why we typically will push clients this way early on to LLCs more than anything.
I have a quick question still about kind of the BD pitch standpoint. So I agree with you. It's especially probably for like a lot of us in this range, getting people to set up the form an entity is a lot, we have access to that, and it's a little bit of an easy pitch. And then for a lot of people, it's like, okay, I've got my entity, now I'm good. And, I'm always trying, okay, well, what about your operating agreement, or if it's a different entity? That gets a little harder sometimes. So do you have, the way you put it up on the slide, it's kind of like, oh, well, if you don't have it, then you've got statute, and they've got it figured out. But do you have like horror stories, or how do you deal with that to get that person over the hump?
Yeah, that's a great question. I mean, do you want to be in partnership with the guy's wife or with her husband? What happens if somebody dies, is disabled, gets arrested? If you have a small business, many times it's very personality driven. You only want certain owners, and so maybe we're 50-50, but I put more money in, and I want to make more of the decisions than you. I want to get the first profits. I want to get a certain return on my investment. There's so much you can do, and you can do it by asking questions. How would you like this to happen?
Gotcha.
And, how do you envision it?
And because, like Phil said, the operating agreement can just include all sorts of separate agreements that you might not immediately think is just the corporate governance and like cash distribution. A lot of what we see for entrepreneurial startups is confidentiality agreements can be put in there. You can put in there covenants not to compete, which is another big one. Are you, you and your buddy, you started this business, are you required to devote all your time to the business? Are you required to just devote some of your time? So, I mean, it can, because of the flexibility of the operating agreement, from a sales pitch perspective, it can be any type of questions and issues that you want the parties, the owners, to agree to.
And we have some good forms to use and some good checklists and memos. And so if you need to go make a pitch informally or not informally and to talk about why you want an agreement, we can help you out with that and give you like a cheat sheet of things to talk about. Excellent. But it can be a great, I'm sure our litigators can tell lots of stories about what happened when they didn't have an agreement. They may be better salespeople than we are.
Well, I know my sales pitch would be, or is, with employment agreements, is apologetic. They don't see the pitch coming, and it's almost as if, look, you have that, and I apologize. You don't want to hear a lot of legal mumbo jumbo, but I just feel I don't do my responsibility. If I don't share with you, you may want to look into that, because I've seen a lot of nightmares from people who have just left it the way you are, and I wouldn't want to see it happen to you. And generally, they have to proceed. At that point, well, what can happen is the seated question, and it works every time. I've seen it, from an employment, if you don't have a contract, oh, well, we don't want that. So, some of it is clients don't like answering questions where you say, how come you don't have this, or that? You bring it on slowly into the conversation so they perceive, well, geez, I don't want to be in a situation where this guy thinks I'm already at risk. Just little point.
Yeah. And another point too is whenever they're setting up a new business, coming up with their idea, their plans for the future, it's ideal. We know that you're going to do well. You're planning for the sunny day, but what if you were to imagine, speaking to the other person, what would you imagine if things were going to go wrong? If you were to have a difficulty, if you were to have the proverbial business divorce, it's good to have these documents and these things thought through ahead of time, so that it's much more efficient and clear for everyone in the end. It's good to think about that on the front side, much easier, much more efficient. So that's usually a good way to introduce and have those discussions, and then to get in and help papers to get them to the point.
And then ask them if they have a will.
There you go.
I mean, while we're putting it out there.
Knock this thing out, $1,500 a time.
Maryland now has serial LLCs. Maryland does not. I know it's been kicked around a few times, but it's never actually gotten anywhere. They do have serial LLCs in Delaware, is where it's really big. And I'll be honest, I am not terribly familiar with them. I don't know if you are, Phil.
I just had an issue with the serial LLC in a pretty sophisticated business, real estate transaction. Serial LLCs, you have different classes of membership. In an LLC, you can have different classes of membership interests. But then, effectively, the concept of a serial LLC is you can then assign different assets and properties within that LLC, different series within the membership rights. but you don't have to document or notify the government. Effectively, it can be kind of behind the screen, under the table type of stuff. And so the idea is that you effectively can have profit interests versus voting interests, something that you guys, I think, will be talking about here. You can effectively allocate different business interests, again, sort of under the table and invisible to a lot of government regulation within the LLC. So it's, again, we're talking about ways to protect people and chop liability up and whatnot. LLC was the latest and greatest in the early 90s, while frankly the serial LLC is sort of the newest part of that.
So what you would do, if you wanted to do the same concept in Maryland, you'd form a series of individual LLCs, and you would just assign assets and liabilities and contracts to each one of those LLCs. And it sounds like the serial LLC statute allows us just to do all that within one agreement by forming separate ownership types, series of ownership. Most people are familiar with corporations and having different types of stock, preferred equity, and common stock, preferred stock, common stock. In LLC, you can do that too. You can just agree to have, Series A, Series B, Series C, and each one can have a slew of different rights and obligations. And using the serial LLC, you can do it all within the company. In Maryland, you'd have to form different individual LLCs for each type of, if you wanted to separate the assets out to different ownership.
I want to make sure I leave enough time for Jordan.
Oh, sure.
The point of this slide is just the fact that there's much less formality involved with an LLC, therefore an LLC is usually a lot easier to use. Okay. Just bottom line for me and for many of my clients is it comes down to the LLC versus the S Corp. Which one is better? And sometimes the question becomes, should I be an LLC taxed as either like a self-partnership or taxed like a partnership, or should I be an LLC taxed as an S Corp? That's the most common type of question that I'm asked at the beginning. And with that,
we get to now it gets to really fun.
This is
where some of these that Phil and I were talking about will start to coalesce a bit when we're talking about S Corps, partnerships, C Corps. So for tax purposes, we have different entity types than what we would have had for the state law. So I'm going with kind of the most simple to the more complex. The first entity type are disregarded entities. You have partnerships, you have S Corps, you have C Corps. Then there's some others that are just not going to be applicable for this, trusts, cooperatives, some other things. But what you'll notice up here is you don't see LLC, you don't see limited partnerships, you don't see limited liability, limited partnerships. This is what you have for tax purposes: DREs, partnerships, S Corps, and C Corps. So if you talk to me about forming an entity and I start talking about partnerships, stop me and say, wait, it's an LLC, right? Right, but it's an LLC that's taxed as a partnership, or it's an LLC taxed as a C Corp or an S Corp. So let's talk about what they are. We have the general concept up front, which is pass-through versus entity taxation. And the question essentially is, where are taxes paid? Where are income taxes owed and paid? When you have, tax imposed in one level is generally avoidable because it avoids double taxation. Double taxation meaning the same income gets taxed twice rather than once. Double taxation happens where the corporation will pay income tax when it makes money, and then it will distribute cash out to its owners, and then the owners will pay income tax when they receive money. And I'm going to show you an example at the very end of how significant this difference is when you're selling all the assets of a company. It's pretty remarkable. So then the alternative is pass-through, where the entity doesn't actually pay the income tax itself. It just pushes all its income tax out to its owners, and the owners pay the income tax just at that one level. So disregarded entities they're pass-through entities. They're only available to sole proprietorships and LLCs with a single owner. As you can guess by the name DRE, they are not even recognized separately for the IRS for income tax purposes. And I'm careful to say income tax purposes because they would be responsible for separately paying employment tax, for example. So if you have a sole member of an LLC that is a disregarded entity, so it doesn't pay any income tax, it would still have a withholding obligation for employment taxes. The nice thing about them is there's no separate return. They are extremely simple, and they are extremely flexible. Because of the fact that they're not even recognized, one of the things that we see, and especially in the post-Tax Cuts and Jobs Act era, without getting way too much into the details, there was a concept called a 1031 exchange, where it used to just be you could exchange identical property, like-kind property, and not pay any tax on it. And it used to be applicable to just all sorts of assets. One of the more interesting ones I've seen were franchises. So if you owned a McDonald's franchise and a Burger King, one guy owned a McDonald's and one guy owned a Burger King, you could just trade, essentially, and not pay any tax and just trade businesses. Under the Tax Cuts and Jobs Act, you can't just do a 1031, that type of exchange with anything. Now you can only do it with real estate. And real estate's a little trickier to exchange. But because a disregarded entity is not separately recognized by the IRS, and because all of its assets are deemed owned by the owners, you can actually exchange LLC interests if they're sold, if it only has a single owner, if they're disregarded and they only own property, you can actually exchange LLC interests and still treat that as an exchange of real estate. It's a little esoteric, but it's the flexibility. The only point I want to make clear is the flexibility of having a disregarded entity for tax purposes. So pros and cons, you're going to see this throughout the slides where I try to identify some of the pros and cons of these different entity types. So the pass-through taxation, so again, one level of tax. It's simple. There's no separate income tax filings. Exit planning is super easy because of the ability to sell your stock, which is treated as an asset sale, or sell your interests, which are treated as an asset sale. Again, a new thing in the Tax Cuts and Jobs Act is the 199A deduction. The Tax Cuts and Jobs Act says you can essentially deduct 20% of your business's income if you're certain entity type. So huge tax savings available there. There are some disadvantages because the company is not separately doesn't have a separate existence. The owner will pay a self-employment tax. Because of the way the 199A works, you can have some limits on that deduction. Under the Tax Cuts and Jobs Act, again, one of the things that a lot of people in this room groaned about was the cap on $10,000 of state and local tax deductions. So it used to be that you could deduct all the taxes you paid state and locally on your federal income taxes. Now it's capped at $10,000, and if you're a disregarded entity, that $10,000 cap applies to your business taxes also. And then some fringe benefits limitations. So those are disregarded entities. Remember, pass-through, single owner, so sole proprietorship or an LLC with one member. Partnerships, again, this is most LLCs it's most LLCs with more than one owner, and it's all state-level partnerships. So this is a pass-through entity, more than one owner. The partnership's profits and losses, so the business's profits and losses just get allocated and distributed out to all the different members. So the partnership creates its 1065, the tax partnership creates its Form 1065 return and just throws K-1s off to all of its owners. And that's where...
Let's just pause for a second.
Yes.
Is everybody familiar with what a K-1 is?
Yeah.
So like as an employee, you're probably used to getting a W-2 from prior jobs. So a K-1 is the equivalent of a W-2 for a partnership.
Okay.
So it tells the partners, here's the income attributable to you.
Okay.
A lot more pages.
And a lot more boxes. And yeah, because it will basically list out all of the partnerships, income, credits, all sorts of tax attributes that now as the owner's responsible for taking into account on their own personal taxes.
And I guess the other thing is, on a W-2, your employer is only telling you and the IRS actual cash you received, and then you're taxed on that. Whereas a K-1 can report out phantom income. So if the entity, the entity might not have attributed out cash, but they're still telling the IRS to treat you as if you got the cash, and that's called phantom income.
Okay.
Yeah, one of the disadvantages in some sense is that you need to have, people need cash to pay their taxes. And what you'll see and what we'll probably mention in later sessions when we're talking about operating agreements is tax distributions. And so we'll require the disregarded entity, the LLC, the partnership, to actually pay cash out, no matter what, just so people can pay their taxes. Again, a little bit further into the weeds here. There's some situations where a partnership may directly pay income tax under some new rules effective January 1, 2018. The real takeaway is that second bullet point, that this is where you address, these are the types of things that you address in an operating agreement or a partnership agreement. And it's, again, that kind of extra selling opportunity, that business development opportunity that we have is, we looked at your operating agreement and it was last revised in 2012. Well, nobody prepared for this because this was all new in 2018. Did you know that the company could be liable for taxes even if certain members were no longer, if you were audited for the 2019 tax year, and people had left, then the company and new owners are stuck with the bill. So can we address, that's something that you might want to think about and something that we can address in an operating agreement.
If you have an S Corp and one of the S Corp owners, so to speak, doesn't pay their taxes, is that tax liability redistributed to the other S Corp, or is just forfeited?
Well, the tax liability, the IRS would go after that partner.
Right, but there's no re-attribution of the unpaid tax to the other S Corp members.
Right.
Right.
That's right. So that same concept that we were just looking at in the previous slide has not been incorporated by S Corp yet. I say yet. Presumably it could. So pros and cons, again, tax advantages, we get the pass-through taxation. As you're going to see, it's insanely flexible, especially as compared to an S Corp, that 199A deduction. This fourth bullet point is key. You can allocate income however you want. So, where we usually use that flexibility is you have a business, and this happens a lot of times, you have the ideas guy and you have the money guy. And the money guy saying, look, I want to get paid out first. And then this other guy with his ideas, he can get paid afterwards. With a partnership, a tax partnership, you can allocate it that way. You can say, income gets repaid directly to money guy until he's totally paid back, and then we pay equally to both of them. As you'll see, that's not an option in an S Corp. By default, it's not an option.
If you have a multi-generational family, let's say, Pa has lots of money and lots of tax, but you've got, new kid coming into the business.
Yep.
Can you, through that, allocate the income back to the low bracket taxpayer?
You can.
And keep it, so to speak, in the family, but not paying taxes in the collective.
Yeah, that's one of the flexibilities that you get with having a partnership.
Common term, you might, for the allocating income in virtually any manner, a common term of art is the waterfall provision. In an operating agreement, it's often referred to as the waterfalls. How does the money flow out from that's earned or
Yep. So when somebody mentions, if you happen to be talking to somebody that with a partnership or LLC and they talk about their waterfall, that's what they're referring to. The disadvantages, so the tax regime, the portion of the tax code dealing with tax partnerships is probably the most complex portion of the tax code, just in terms of its understanding. The regs, like all the regs are dozens of pages long. It's complex. So it's not something people should really try to do on their own. So anytime I set up a business, an LLC with two owners, I tell them, please get an accountant right now. Just start off with good books, with good records. Other disadvantages is, again, we have the self-employment concept, we have the SALT limitations, and certain fringe benefits that are unavailable. So S Corps. S Corps are interesting. This is a pass-through entity available to most state entities that even have one owner. See where else. So S Corps, because they're subject to subchapter S of the Internal Revenue Code. So for tax purposes, they'll be treated in most cases as a corporation, except that income passes through the shareholders. So as we'll see on the next slide, a C Corp, or two slides, a C Corp is double taxed. It's taxed at the corporate level and it's taxed at the shareholder level. An S Corp doesn't tax at the corporate level because all the income flows through like it would in a partnership, just to the owners. But there comes with some restrictions. And the restrictions are specifically in ownership. It's limited to 100 shareholders. All the owners must be U.S. individuals, the state, certain trusts, and charities. there's only one class of stock, and this is what really distinguishes it from a partnership. And we'll get into a little bit later in a couple more slides, where you could have tax consequences if you have a late election. But I really wanted to point out, again, the limitation on size, that can be a big deal, the limitation on who the owners are. So if somebody, and especially in this area, we do have a lot of folks who, maybe recent immigrants, might have people in the old country that also want to buy in, well then S Corps are out. Like just immediately they're out of the picture. If people want to invest through their other entities, again, out of the picture. The one class of stock only in economic terms. This is where we can't have that waterfall that Trent mentioned that we discussed a couple of slides ago, because everybody must have an equal right to distributions. So you can't say money guy gets first dibs. That doesn't work. Money guy and ideas guy have to get them, at the same rate. And then at dissolution time, if the business closes, money needs to go out equally in accordance with ownership. The misleading thing when you hear one class of stock, you can't have different voting rights. So you could have the money guy be non-voting because he's just putting money in. Why should he get a vote? Versus the ideas guy could have just all voting rights. But for economic purposes, one class of stock. So we get to our pros and cons. The pass-through taxation, right? So one level, it's simple as compared to partnerships. They're just easier to do from a tax perspective, income tax returns and such. You would have, let's see, 199A deduction we discussed, exit planning. We'll see later on why it matters to be passed through when it comes to exit planning. Some of the disadvantages is the limited ownership and income allocation opportunities. And along with that, the phantom income is also an issue here for the exact same reason. There could be, book income at the entity level, but then it gets pushed out, and if the owners don't take actually any cash distributions, they're still responsible for income. The bottom bullet right there is something specific that we see in S corporations, and it's this issue of reasonable compensation. So what people do is they try to get cute and say, okay, well, we can only have, we have to have equal economic rights. But what if money guy just gets paid a salary of $500,000 a year for the first few years? Well, then the IRS says, well, no. That's not reasonable compensation. That was you trying to cheat the system of having one class of stock. We're going to treat that as a second class of stock, and you're no longer an S Corp, and now you're subject to the C Corp horror of 2 levels of tax, and you owe back taxes, and blah, 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 blah. So that reasonable compensation is something that we look out for. Is everybody that's doing this, that's offering, providing services to the company, that's also an owner, are they being paid reasonably in the market? So we mentioned partnerships and S corporations are both pass through, held, owners both get K1. What are our differences? So partnerships, no limits on the ownership. You have that flexible allocation, that flexible waterfall. Third point under partnership, the service providers can be granted profits interest without triggering phantom income. Profits interest is something that you can do with a partnership, again, an LLC tax is a partnership usually, where the service member doesn't receive equity, but their equity interest, their ownership interest, isn't of any historical equity in the company. It's only future growth. So they don't pay they don't get any benefits until there's future growth of the company. And you see that a lot in private equity manager, hedge fund managers are typically paid with profits interest or carried interest, they also call them. Let's see, you have, again, self-employment happens on both. One of the more interesting ones is, fifth one down, the tax-free reorganizations. This is further than we need to go in this conversation, but there are tax-free reorganizations in the tax code for C corporations and S corporations, because like I said, S corporations are treated as corporations for all purposes except as specifically stated in that portion of the tax code subchapter S. There's no technical terminations and partnerships in the Post-Tax Cuts and Jobs Act era. But if you violate an S Corp, if you violate a single class of stock, you turn into a C Corp. So S Corps have kind of their own slew of risks with them, but they have the benefit of some simplicity compared to partnerships. And if you have a sole owner, there can be the advantage to having an S Corp because you can get deductions for, for employment that you pay to the owner, for any wages paid to them. All right, C Corps. These are the double tax entities. You'll see this automatically for state level corporations. So if you form a Maryland Inc., if you form a Delaware Inc., an Inc. of any jurisdiction, it will automatically be a C Corp. And again, C Corps, subchapter C of the Internal Revenue Code. So the pros and cons, one of the nice things that happened, and this is why it happened in the Tax Cuts and Jobs Act, is the corporate income tax rate was dropped to 21%, which means if you're a new business and you're just planning on growing and you don't plan on actually distributing any money out, the question then becomes, well, now that the corporate rate is now taxed at 21%, why don't we just form a C Corp and just hold our money there? You'll eventually get taxed on retained earnings if you do that for too long, but it adds a little bit more complexity to the decision-making process in choice of entity. Still not recommended, simply because even though it's 21% today, Lord knows what will happen if the parties change, and it could change. It's kind of the short version. Again, the $10,000 SALT tax SALT deduction limitation doesn't apply. We don't have issues of phantom income. So to Marty's point, where you wouldn't actually receive, you'd have income attributed to you, but you wouldn't pay cash. That doesn't happen with shareholders in a C Corp. Shareholders in a C Corp don't get any income until the money is actually pushed out to them. And one other interesting thing is the qualified small business stock exemption. If you form a C Corp and you have assets the entire time of your ownership of the life of the C Corp of less than $50 million, the owners could later sell their interests, their stock to a third party just to sell the entire business and not pay any income when they broke the business. Which sounds all well and good, but there's still the issue. Historically, you're subject to double tax. As we'll get in, as probably beyond the scope of this, but big picture is buyers usually don't want to buy stock because a stock sale comes with all of the molds and issues that might have plagued the company. So it sounds great, and if the situation happens, it's good. And we usually ask the question when a client comes in and they're selling all the stock or interests of their C Corp, can we make this work? We have yet to see a situation where a buyer's actually been willing to play ball. Sorry. Two disadvantages, 2 levels of taxation, costly exit planning, which again, I'm going to show you an example. And the 199A, the 20% deduction doesn't apply. So C Corps versus pass-throughs. Here's a handy chart that just summarizes it. I think everybody has this in their PowerPoints in terms of the form of the business, the level of tax, income rates, and the regulatory framework. C Corps have a very developed regulatory framework that can be, regulators like to see that. But let's get to how this happens. So I've mentioned that partnerships, disregarded entities, S Corps, C Corps are not a state concept, so fine, they're different. How does it happen? And this also goes to what we were talking about with Pat before, and excuse me, and with Phil. So we have the check-the-box regulations. So a business entity, when you form a company, it can be one of 2 things. It's either a per se C Corp or it's an eligible entity, meaning it's an entity eligible to choose its tax classification. Corporation's real easy. An Inc. is automatically a C Corp regardless of the number of owners. The only thing a C Corp, an Inc. can do is elect to be an S Corp. If you make the S Corp election at the beginning, it's always an S Corp, and that's well and good. You can also make a late S Corp election, but if you do that, you bring in a lot of the C Corp double taxation can still happen even after you convert. So if you're going to be an S Corp, do it from the beginning. The other is an eligible entity, and like we said, it's either an eligible entity or it's a per se C Corp, which means everything that's not an Inc. is an eligible entity. If an eligible entity has 1 owner, it's automatically a disregarded entity, or it may elect C or S status. So the best example, again, is the LLC with a single owner. And the LLC with a single owner is the most flexibility because it can be a disregarded entity by default, or it can elect C or S Corp status. An eligible entity with multiple owners, so partnerships, right, by default, that's a state law partnership, can either be a partnership or it may itself elect C or S corporation status. That's how it happens. That's how you have a state law LLC and you have to ask the next question, what are you for tax purposes? Because of all this. And if you have a disregarded entity and you add a new member to it or a new partner, just automatically, no election or anything, just boom, you're a partnership. So exit planning, this is the bit that I've teased. So entity type is frequently a concern when you're selling a business. Sellers, I think that's my next couple slides. Yep. Buyers will want asset treatment because they just buy the asset, they take what's called a cost basis in whatever the purchase price was for their assets, and then they get to make, they can deduct their prices, they get to depreciate those assets. So it's good for buyers. Sellers want stock treatment because if you sell stock or membership interest, it's all capital gain, which is taxed at a lower rate. And from the seller's perspective, it's just a whole lot easier. Here's my stock, and now you have the whole business. This is where things get really gross with C Corps when you're selling its assets, because now remember, you're paying 2 levels of tax. You sell all your assets, the C Corp is paying the same level of tax, and then you're distributing all that gain out, and all those shareholders are now paying their personal income taxes. And this shows how dramatically that difference can be. So if we look on the left, it says LLC tax to the partnership, could also be any other type of pass-through entity, and then we have a C Corp. You'll see there's no corporate level tax for an LLC versus the C Corp ends up paying tax is in the amount of $23,000 just at the top level. Net after tax, it gets distributed out. We have the owners paying their capital gains, their state taxes, et cetera, et cetera. But just look at the last line, the last 2 lines of the effective tax rate. The LLC paid an effective tax rate of 25%. The C Corp paid about 43% in taxes, simply because of the type of entity it was. All other things being equal, there's some other things that'll shift those numbers a little bit in either direction. But the real takeaway is this is why, as much as we talk about C Corps, oh great, there's no push out, no phantom income. We only need to worry about money at this level. Most business owners are going to sell at some point, and usually that's where we see them, especially in our practice. And if they're a C Corp, they're paying a huge tax bill, and we need to figure out ways to change that. I threw these up here just so that way it would be available to you. These are the assumptions that we used on that prior slide. I couldn't. How could I? How could I have numbers and not show how I got there? So that's kind of where this question about tax treatment comes in. And I believe that was the next to last slide. So anybody have any general questions? I know I kind of breezed through quite a bit there.
You have to update your picture with beard.
I do. I know that picture is old.
That's my question.
And your email address is a little
Oh, wow. How did I miss that?
Wow.
All right. By the way, my email address is actually JHALLE for those playing the home game. So that's what we've got. Do we have any, before we stop the recording and we can get into more specific questions and specific discussions, are there any other general questions in any of the other offices also? Any general? No? Okay, so that's it for the recorded session. I guess we can stop the recording.